Welcome back to Rationally Based, a podcast about law and politics on the edge. Kathryn, what's on deck for today?
Well, we're covering two topics today. First, a major development from the Supreme Court. The court has struck down some of President Trump's tariffs. There were 3 conservative justices in the majority and 3 in the dissent. We'll talk about who's right. Then, do liberals have a radical plan to reshape the Supreme Court? The New York Times seems to think so, but we're skeptical.
Let's dive in. I'm your host, Ilan Wurman, a law professor at the University of Minnesota Law School.
And I'm Kathryn Johnson with Center of the American Experiment.
And our third co-host, Grace Keating, could not join us today, but we will make do. And we also have some exciting announcements that we are anticipating making. We're going to have some guests come on the show. We're going to have our first live taping coming up in a few weeks. So stay tuned for all of that. But in the meantime, Kathryn, where should we start? I guess the tariff case?
There's only one place to start, right? So the Supreme Court's ruling striking down Trump's tariffs under the IEEPA.
IEEPA.
IEEPA
is what those in the know call it.
That's what
IEEPA.
I was wondering. Because then there's this other thing that you've said. UPA? UPA? UPA?
I don't know what that is.
Okay, never mind. We had a previous episode. You were like calling something a UPA.
I'll go back and look.
Okay.
IEEPA is
This
what
is
we call
IEEPA.
it.
So first of all, we should talk about what the statute says. 3 Republican-appointed justices, Roberts, Gorsuch, and Barrett, joined the 3 liberals to conclude that the statute did not authorize the tariffs, whereas another 3 Republican-appointed justices, Thomas, Kavanaugh, and Alito, said that the statute would have authorized the tariffs. Who is correct?
So this decision, these sets of opinions, I should say, is just a feast of legal education and statutory interpretation. And who's right about this? Well, let's work through it. It's going to be one of those situations like about the Fifth Circuit habeas ruling where actually both sides make really, really good arguments. I know, crazy to think that. But
people don't like admitting that, but I do feel like it happens a lot.
Yeah.
And your tweet got a lot of traction where you said, I read both sides and I agreed with both of them when I read them.
I said, darn. Well, I didn't say darn. This is a family-friendly podcast. I said, darn, I read the majority and thought they were right. And then I read the dissent and thought they were right, which is like, if you don't think that, there's probably something wrong with you. But in any event, ultimately, what's the answer here? On the statutory interpretation question, I think the dissent had the better of the argument, but there are other things going on in the case that might not involve statutory interpretation, like the non-delegation doctrine. There's this sort of legislative veto question lurking in the background.
Okay, so let's take a look at the statute, first of all. What does it say?
So there are really 2 relevant parts. The first is it requires the president to declare an emergency pursuant to the National Emergency Act. Now, it's not exactly an emergency. The president can declare that there is any unusual or extraordinary threat. Okay, so it doesn't have to be an emergency as such, but any unusual and extraordinary threat to America's national security, foreign policy, or the economy that's originating primarily outside the United States. And once the president makes this emergency declaration, the powers in IEEPA come into play. And then there's this question as to what those powers are. So here the president invoked or announced or declared 2 unusual and extraordinary threats originating outside the United States. The first was these massive trade imbalances, and the second was drug trafficking coming in. And I guess the idea was that foreign countries weren't doing enough to prevent the trafficking of drugs into the United States, and President Trump wanted to turn the screws a bit using the tariff power to address that problem. So
I see that. The drug trafficking, I see that being an urgent threat. I'm not sure the trade imbalance is really hitting it for me. Is that enough of an urgent need? I mean, do we always need to address every trade imbalance? I don't think so.
So, I mean, is it an unusual and extraordinary threat? I mean, we kind of have regular trade imbalances, but even putting that all aside, and I know we'll get into this a bit later, there are other tariff statutes out there that address trade imbalances, which is why maybe that emergency was not so much an emergency, or that declaration was probably not so improper. But certainly the drug trafficking one is totally plausible.
Well, I also wonder, based on what the statute actually says, one of the things that I see as an urgent issue is just how much of our necessary stuff is made over in places like China and India overseas. I mean, especially with COVID, that just happened, knowing that the vast majority of our medicines and our pharmaceuticals are made overseas. To me, that seems like an urgent problem. But I haven't heard anyone talk about that. And especially when it comes to national security, there's so many things that we need to be producing at home for our security that aren't right now.
Yeah, that's a great point, Kathryn. So in terms of the actual declaration to invoke these powers, maybe a trade imbalance doesn't make sense on its own, especially because there are other statutes out there addressing trade imbalances. But certainly when it comes to questions of like, oh, we need pharmaceuticals, we need rare earth minerals, manufactured, mined or something in the United States, that would totally plausibly, in my view, fall under this triggering part of the statute, right? But even then, that really wasn't at issue in the court's opinion. No one was really questioning, although some of the litigants questioned whether this declaration was proper under the statute. What they were really questioning in this case was, even if that declaration were proper, what authorities does the statute actually give the president in that situation? And the answer is that the statute authorizes the president to regulate the importation of goods coming from foreign countries. And is the regulating the importation of these goods, does that include the power to impose duties on them or tariffs on them? And so the statute in full says the president can regulate, direct and compel, nullify, void, prevent, or prohibit. So these don't sound like financial exactions, but the president could prohibit like the bringing in of goods, any acquisition, holding, withholding, use, transfer, withdrawal, transportation, importation, or exportation of or dealing in or transactions involving any property in which any foreign country or a national thereof has any interest. And so the question here is imposing a tariff regulating the importation of foreign property. And you had the three, as Kathryn, you mentioned, three conservative appointed judges, Chief Justice Roberts, Justice Gorsuch, and Justice Barrett, joined by the three Democrat-appointed justices to conclude that this did not authorize imposition of tariffs, that regulation is not the same thing as imposing tariffs. And then you had the three other Republican-appointed justices, Kavanaugh, Alito, and Thomas, arguing that regulating the importation of foreign goods can, in fact, include tariffs, and historically was understood to include tariffs. And if you could prohibit the goods from coming in entirely, then you can also presumably impose an exaction or a duty on them. So that's the debate. And three of the liberals, so the three Republican-appointed judges in the majority also would have deployed something called the Major Questions Doctrine, saying that Congress must speak clearly when it delegates significant, authorities of significant political and economic implications. That the three liberal judges refused to join that part of the opinion, which is something that
ironic.
We'll get into whether they are being hypocritical, but that's the debate.
Well, and we have already established here on this podcast that the power to tax is the power to destroy. Bring back the pillow. I think that there's something in that makes me think definitely that's regulatory.
We do mention Chief Justice Marshall in McCulloch v. Maryland a lot. So it is true that the power to tax is the power to destroy. Does that imply that taxes can be regulatory in nature? And I think the answer is yes. Some taxes are regulatory in nature and some are not. Some are for the purposes of raising revenue, but they incidentally, affect people's behavior, right? So like we tax whiskey or alcohol rather than taxing milk. Why? Well, because if we have to discourage one or the other simply by raising the price, then we'd rather discourage alcohol consumption. But the purpose of the tax is still to raise revenue. It's not regulatory, right? The regulatory impact is incidental, but some taxes or fees are regulatory in nature. And so that is, I think, what the dissent suggested.
I just don't really feel like it's the government's role to care whether I'm drinking whiskey or milk. What's it to you?
That's totally
that's a
fair.
Separate question.
That's totally fair. But the government does have to raise revenue somehow for its purposes. And it could do things without taxes. I mean, it could sell public lands. It could pillage in war, I guess. We could steal money from other countries. We could borrow money, if we want to be more polite about it.
So those are the two categories, kind of either to regulate or to raise funds. And these tariffs, I think, were clearly to regulate, right? We weren't trying to we don't need money as a country. Actually, we probably do. But anyway, we weren't doing this to just raise funds. It was as a leverage point kind of, right?
Yeah,
so it's regulation?
Well, yes and no. So it didn't help. So the Solicitor General took the view that, look, if we didn't raise a single penny from these tariffs, the mission would be accomplished because we want to get rid of these tariffs because we want them to have the regulatory effect that we're talking about. And so he insisted that they weren't imposed for the purpose of raising revenue. But then you have Scott Bessent and President Trump, truth socialing or tweeting about stuff being like, look at how much money, we've raised. We can replace the income tax. And then it's like, okay, that's getting a little bit awkward. So are you actually intending to raise revenue with this? So here's the reality why I think on this question, the dissent probably had the better of the argument. And it's because it's very difficult for me to separate out the answer to this question, what are, regulations of importations, whether they include tariffs, from my knowledge of the history of the American Revolution. So
please enlighten us.
I feel like, we talk a lot about the upcoming semi-quincentennial of American independence. And so let's talk about the American Revolution. Why was the Stamp Act so problematic in 1763 or 1764 when that
taxation
was imposed?
without representation, right?
Taxation without representation. But the reason everybody knew that the Stamp Act or the stamp tax was taxation without representation is because it was an internal tax. It was a tax imposed domestically. It was not a foreign duty, a duty imposed on the importation of foreign goods. So why is this significant? Not because external taxes without representation are okay. That's not true. It was because they understood that some external duties, external taxes, weren't actually taxes, but were regulations of commerce. So why was the Stamp Act problematic, but not the Sugar Act of 1733 or 1734? Well, because the Sugar Act was understood not to be for the purpose of raising revenue. It was to promote the molasses industry in the West Indies, on
Big
the colonies.
molasses.
Yeah, as the sugar trade, right? And so the colonists understood that the power to impose financial exactions on the importations of goods could be for a purpose of raising revenue, in which case it was not okay. But it also could be, at least without representation, without the consent of the people, but it also could be a regulation of the empire's trade, and that was conceded to be a power that Parliament could exercise on behalf of the whole colonies. So when I see regulate the importation of foreign goods, I think, oh, of course, that's what Great Britain did. That's what the colonists conceded to the empire. Now, the question, of course, is that was 250 years ago. Or it was 200 years before IEEPA was enacted. IEEPA was enacted in 1977. And so the question is kind of whether Congress used it in this way. And here is there a through line, right? I guess is the question between how Congress or how the American colonists understood it in 1763 or 1776 and how Congress understood it in 1977.
Is this like a big question? Does that matter how Congress understood it? I mean, why do we care about Congress's intent, or do we care when they make the law?
Well, this is a profound question of the judicial role and statutory interpretation. So there's this debate over, what is the object of statutory interpretation? Why do we interpret statutes? And some people say, we just look at the text of the statute because all that matters is how people would have understood the statute when it was enacted, just like how the people would have understood the Constitution when it was enacted. But other people say, well, you really need to get at the legislature's intent. Why? Well, because the legislature, for whatever reason, because they were democratically elected or for some other reason, is the legitimate lawgiver, the legitimate authority with power to change the legal state of the world. And so it's their intent that matters. Now, how do they convey their intent? Well, through words. And so presumably they used words in the way that ordinary people would understand them. So that's why we care about Congress's intent, partly because, to understand the words that they used, we have to understand the words that they used as it would have been understood at the time.
Oh, sure.
Right?
Yeah,
because,
okay.
The Constitution has a clause about domestic violence. Does that mean spousal abuse? No, it means insurrection.
Oh!
Okay, it means insurrection. So what matters, the object of interpretation is sort of the meaning and or intent at the time it was enacted.
Okay, I guess you've convinced me. But these things are all on balance, right? So you take those all into account. Is that what a good judge would do?
Yeah. So some people are very sharply distinguish between intent and meaning, and original public meaning. I think that's really overstated because, again, legislatures convey their intent using words. And so presumably they intended the words to be interpreted as ordinary readers would interpret it. And of course, people tend to interpret words in context. And part of the context of the words is, hey, why did the legislature enact this? So this is a super interesting debate in statutory interpretation. But I don't think anybody here in this case, like of the 9 justices, really disagreed with it. I think everyone understood that the question was, how did the Congress that enacted it understand that phrase?
Yeah.
So the fact that the American colonists understood it in a certain way doesn't mean that Congress 200 years later would have. But as the dissent says, channeling actually law professor Aditya Bamsai at the University of Virginia, who had a very interesting brief in this case, Congress had used the phrase regulation of importation arguably to include tariffs before, and pretty recently prior to enactment. So there's a statute called the Trading with the Enemy Act. Enacted in World War I. It was spicy. A lot of spicy things happened in World War I, including suppressing a lot of First Amendment speech, and we'll talk about those some other time. But the Trading with the Enemy Act, totally legit, and also authorized the president to regulate the importation. And not long before IEEPA was enacted, it was either President Ford or President Nixon had invoked the Trading with the Enemy Act to impose duties, tariffs on foreign goods, and this was upheld by the court that existed at the time to address such matters, kind of like the Court of Claims or today the Court of International Trade. The exact court no longer exists, but they upheld this, and it was not appealed to the Supreme Court, and this was just before IEEPA was enacted. And there's also a provision of, I think it's the Trade Expansion Act, which was enacted in the 1960s or 1970s, that allows the president to adjust the imports of foreign goods, and that was held by a unanimous Supreme Court in a case called Algonquin, to authorize tariffs. And so you have TWIA, the Trading with the Enemy Act, that was used, the regulate the importations was used to impose tariffs. You have the adjust the imports of. What's the difference between that and regulate the importation of? I know Kathryn is giving me that face. Anyway, this was all before Congress. And so the dissent, I think, relatively persuasively shows that that therefore Congress understood that regulations of importations included this power to impose duties. Now, it's true on the other side that Congress, when it does these trade statutes and these tariff statutes, usually uses the word duties or tariffs, right? Or financial impositions or something like that. But those statutes are all tariff specific. The IEEPA is a much broader statute, giving much broader authority to confront multiple emergencies, or emergent situations. So it doesn't follow that just because Congress uses the language of duties in tariff-specific statutes that it would have done that here, right? It doesn't follow that the president, therefore, doesn't have it in this context of the broader IEEPA statute. So purely on the statutory interpretation question, I think the dissent has the slightly better of the argument. But there are other things going on, like the statute used to have a legislative veto. There's this major questions doctrine. There are non-delegation implications, which maybe is what's motivating what the majority actually did. But I know we're going to jump into that. But before, let me just how would if the rationally based podcast were on the Supreme Court. If we were a Supreme Court justice.
I love any hypothetical where I get a lot of power and I get to think about what I do with it.
Hopefully you would exercise it in a reasonable way, constrained by law. And, okay, well, all right, I would, but maybe Kathryn wouldn't. But that's why we're here having this dialogue about the importance of law and legal rulings. Okay, so what puzzles me about this case, we talk a lot about judicial power on this podcast. I feel like I say that every episode. We talk a lot about judicial power on this podcast. Historically, you would have a party with a particular tariff being imposed who challenged that particular tariff. But here, the court seems to address the whole class of tariffs, all the tariffs enacted under IEEPA. But maybe the answer is some of the tariffs are okay and some of the tariffs are not okay. So I would have done this on a sort of a retail basis rather than a wholesale basis.
This was one of my biggest questions. Like, who decided that they were going to address all of the tariffs at once and not looking at them individually, like tariff by tariff?
So I don't know exactly. I suppose if you're the challenger, if your view is that regulate importations doesn't allow any tariffs, period, then you don't have to do a case-by-case basis. You could say this statute doesn't allow any of them. But as a fallback, surely you should have said, well, if regulate importations does include tariffs, it doesn't authorize every tariff, right?
Yeah, can you do that? Like, could they have been like, well, okay, it works under IEEPA, but if you don't think that, court, let's give you another option. Yeah. And then they could have put in some of the other laws that do give him powers.
I think it's called good lawyering, to argue in the alternative, right? Now, of course, also what the dissenter said is, well, even though the president can't do these tariffs under IEEPA, there are all these other authorities that the president probably could do it under, like the Trade Expansion Act and so on, which are quite a bit more constraining than IEEPA, which maybe is a good thing. So in this case, though, the real question is, in my view, like, why couldn't this have been done on a tariff-by-tariff basis? So, for example, under the discussion we just had, not all tariffs are regulatory. If some tariffs are for the purpose of raising revenue, those are out, okay? Now, maybe some tariffs are regulatory, but the purpose for which they're deployed is illegitimate under the statute for whatever reason, or exceeds the authority in the statute. So, for example, imposing a tariff because Mark Carney insults you, or the governor of Ontario runs an ad with Ronald Reagan in it. I don't know if you remember when that happened. And then Trump was like, oh, I'm tariffing Canada over these egregious insults. Cool. Well, that probably violates or exceeds the statute. And then maybe not all of the emergencies are legitimate emergencies under the statute, or at least there's some other. So, for example, we mentioned how there are other statutes out there that address trade imbalances. Well, if there are other statutes out there that address trade imbalances, then it seems to me that those statutes should control this question and that the president can't just declare a trade imbalance emergency under IEEPA and impose any tariffs. So I think it would have been reasonable to say, yes, sometimes regulate the importation of could include tariffs. It doesn't include all tariffs, and it includes tariffs imposed only for certain purposes. And then we look at how other statutes have done it. But the court instead took this wholesale sort of approach. So, but look, I'm not on the court, alas, and they don't always do things that I would do.
That's very interesting. I mean, I guess it's just, I guess it would be harder. Well, is it just because it would be like they'd have to go one by one? The Supreme Court would literally have to go through each tariff. Is that part of it? And so they're like, well, let's just decide them all. But now it seems like their decision means so much less because he can just shift his strategy.
Yes. So it's not just that the court doesn't want to do the hard work of doing tariff by tariff. Probably that's also true. I don't know if litigants want that, right? Yeah. Because then every individual company would have to bring a challenge respecting every particular individual tariff. And you might have thousands of cases involving thousands of different tariffs. And it's like, is that practicable? Maybe not, but it's also like historically how judicial power worked. So I get it's convenient to have the Supreme Court just say, look, rule of thumb, we're going to address all of these tariffs. But I would not have done that. Now, of course, again, to be fair to the majority, they said regulate importation doesn't mean tariffs at all. And so they don't have to get into that because they're just like, oh, they're all invalid because no tariffs are allowed. If you think, however, that tariffs are allowed, it doesn't solve the inquiry, I guess. So to be fair to the majority, right, they got around this problem by saying all tariffs are. Now, maybe part of the reason they made the ruling is because they didn't want to have to go tariff by tariff to figure out what was a regulation and what was legitimate under the statute. And so it was cleaner and easier to say, we're just going to say all tariffs are impermissible. Yeah. But I don't know, that's kind of cheating. But of course, they maybe really thought that, for independent reasons. Or
it's taking the easy way out.
Or they're taking the easy way out, which maybe is what major questions doctrine is for. There's some non-delegation stuff and some legislative veto. But look, that's my view. Close case. I know people hate me when I say that or give me, troll me when I say that, but legitimately, it's a close case. The dissent probably had the better of the argument, but it doesn't mean that all of the tariffs would have been valid under the statute. So that's my hot take, or not so hot take, tepid take.
That's a take that
was, thought out over time. You had all the hot takes last week when all the other podcasts posted emergency pods. We've had time to think and digest about this opinion,
simmered
right?
We've simmered on our take.
We've simmered on it.
Well, you've brought up the legislative veto a few times, but we haven't really gotten into it. Can you explain that a little bit more? How does that play into this?
So what is a legislative veto?
Yeah, I don't know what that means.
The president has a veto over Congress's laws, but what does it mean to have a legislative veto? So this question, although maybe lurking in the background, nobody addressed on the Supreme Court, which is super interesting. And so a legislative veto is this tool that Congress started to use around the 1930s when it delegated power to the president or when it delegated power to the administrative state. In the 1930s, Congress started delegating more and more power, right, in exceedingly broad terms to the president. But as a condition of those delegations, it included what was called the legislative veto. So basically they said, all right, the president, you can declare an emergency under IEEPA, for example, but you must submit your declaration to Congress, and Congress could veto that decision on the back end. Now, you can see why this was an attractive tool, because if we're going to delegate all this power, we want to make sure that we retain, control over policymaking. So it makes total sense as this political innovation. The problem is it makes no sense under the Constitution. Okay, because where's Congress?
A road bump.
That's right. For some people, it's a road bump. Other people would just ignore it, But I hope, Kathryn, for you and me, it would be a road bump.
I'm a fan of the Constitution generally,
okay. It's not just about raw political power. We care about the Constitution, which also, I guess, dovetails into our second topic of the day, whether the liberals have a better plan for the Supreme Court. But that's a little bit jumping the gun. Okay, so under the Constitution, what is the road bump for a legislative veto? Well, Congress can pass laws. Is the legislative veto a law? Not really. I mean, if it is a law, it has to be enacted through bicameralism and presentment, right? Both the House and Senate have to agree, and the president has to sign it. But a legislative veto is just the House or the House and Senate together could just veto something the president does without the president's signature. So that doesn't work. Maybe a legislative veto is like interfering with executive power or is taking a role, a back-end role in how the president executes the law. But Congress doesn't have executive power.
Right.
And if it's judicial power, then Congress doesn't have that. So the legislative veto simply doesn't fit. So the Supreme Court struck down legislative vetoes in 1983 in a case called INS v. Chadha.
When did it start?
So I don't know exactly when legislative vetoes first emerged, but I know there were some by the 1930s. There might have been some earlier. So for 50 years, for half a century, Congress, this was the deal. We'll delegate to the president this power, but we have this legislative veto. Another interesting thing, by the way, is independent agencies. So not only do we have legislative veto, but we delegate to independent agencies. There's a case in the Supreme Court right now that we will talk about over the future of the administrative state and whether independent agencies are even constitutional. But this is crazy. If they strike down independent agencies and they struck down legislative vetoes, would Congress have ever written the statutes that it did, delegating all this authority? That's a question.
Yeah.
So here, IEEPA didn't have a legislative veto, but the National Emergencies Act did.
So it would have to be an emergency that everyone agreed on. It couldn't be just some bunk emergency that is clearly a part. I mean, you can have the same party in Congress and in the president, and maybe they'd all agree, but there's at least some check on the ability to determine if it's worth tariffing over.
Correct. So it's not unilaterally the president's decision. So the president would have declared the emergency and imposed the tariffs, and then he would have submitted that decision to Congress. And we have Republican control, kind of, in both branches.
Yeah.
Depends how you define Republican. That's a separate issue. And so you would have needed a majority to veto that decision. So you would need all the Democrats presumably would have vetoed it, not because they don't like tariffs. I mean, they used to love tariffs, but because Trump.
Yeah.
Right? So they all would have opposed. And then you just needed a couple Republicans to peel off, which surely there would have been some who believe in free trade still. Maybe a little bit.
Maybe, probably.
I'm not sure.
Well, this was kind of one of my questions. Is this another argument because couldn't Congress just pass a law that gives the president broad authority to implement tariffs in theory? Now, we don't have the majority needed to get it past the Senate, right? But is this just another argument for doing away with the filibuster? They could pass a law that allowed him to keep doing these tariffs the way he wants to?
Yeah. So Congress, of course, in light of this decision, could reenact IEEPA or amend IEEPA.
Yeah, just throw the word tariffs in there.
Yeah, it could do that. But there are enough Republicans that probably don't support that project.
Sure.
And even if there were, like, you would have that 60-vote filibuster threshold. But yes, this doesn't look, this decision, as Justice Gorsuch said, right, it's pro-Congress. Congress can still step in. But of course, that all assumes a competent, functional Congress, which is sort of a big if. But
well, and that also goes to the next thing I think maybe we want to talk about is this major questions doctrine, which basically is that Congress can't give up their power that way. Is that right? So even if they were to want to give up a lot of their power to the president, are there some justices that think they can't do that no matter what?
Yeah, so there's a question. So the major questions doctrine, there's a debate over whether this is a substantive canon that we're not legitimately interpreting the statute, or we're not trying to figure out what Congress actually meant, but we're just enforcing some other value in the Constitution, like the non-delegation doctrine, or if it's just this other tool of interpretation. But in a nutshell, the major questions doctrine stands for the proposition that when Congress delegates to agencies massively important powers, powers that are very politically and economically significant, it doesn't do it through language that's ambiguous or broad and vague. It does it specifically.
Okay.
And there is a debate here, which I know we'll get into, over like Justice Gorsuch is fighting Justice Barrett. And it's like, what are they fighting about? And of course, the liberals didn't join the major questions part of the opinion. But yeah, so the major questions arguably is this substantive canon, this thumb on the scale against Congress. And the debate between Gorsuch and Barrett is over whether substantive canons are okay or not. Now, let me one more point, by the way, about the legislative veto. I would support this substantive canon, this idea that, like, now that the legislative vetoes are gone, I would support interpreting every statute that Congress enacted with the legislative veto very narrowly, now that there aren't the legislative vetoes. Now, look, I'm making this up. I'm making this up. And I totally admit it, that I'm making it up. But you know what's also made up? These statutes. Because Congress never enacted them without the legislative veto.
That's so interesting. Yeah, like, would they have thought the same thing? Would they have done the same thing if they hadn't had that legislative veto? I didn't even know about the legislative veto. So I feel like this calls into question all kinds of things that happened during that. That's a long period, 50 years, when they had that.
Maybe the whole New Deal state, which I know we've questioned before under the Commerce Clause, maybe the whole New Deal state is now put into question because all these delegations never would have happened, without legislative vetoes or without independent agencies, which we'll see what happens to them in the Supreme Court.
So why is no one talking about that? That's so interesting.
There was one or two people talking about it on X.
Well, here on Rationally Based, you get the best analysis of all places. But
on major questions, I don't think it's a substantive canon. Gorsuch does. Barrett does not. And so there's sort of this debate between them. And then there's, so I guess to bring it back to the global question, like if I think regulate the importation of includes tariffs, right, then what else is going on in this opinion? If you could read the statute that way, what else is going on in this opinion? Maybe it's the major questions doctrine. Maybe without the major questions doctrine, the majority would have held differently. But with the major questions doctrine, they say, actually, we are holding against the president in this case, though it's unclear exactly if that would have happened. And then there's non-delegation questions. And is non-delegation related to major questions doctrine? So then non-delegation doctrine is just this idea that Congress has to make important policy decisions for itself. It has the legislative power. It delegates to the executive all the time, but there comes a point where its statutes are so broad that maybe the executive is actually lawmaking. So if Congress passed a statute that said, there shall be an interstate commerce commission that shall make any regulations that in its judgment is conducive to the goodness and commercial prosperity of the United States.
Oh, it's like a new Congress.
Yeah, well, exactly. It's like you're basically creating a Congress in the Interstate Commerce Commission.
Interesting. So they can't just like peel off and create a bunch of different Congresses. That's what it's supposed to prevent.
Exactly. So when its statutes, in other words, have to have enough details and enough principles and enough standards in it such that when the president executes the statute, we can all say, okay, that's actually law execution. Congress has made the law, has decided the legal policy questions. The president is merely executing the law, but there comes a point where the statute maybe is so broad that the president is actually exercising legislative power, and that's not okay. And so that's lurking in the background here. I mean, there's a debate about the non-delegation doctrine, which is kind of super weird, about like the Thomas has an opinion about this, Kavanaugh talks a little bit about this, and then Gorsuch talks a little bit about this. But maybe there's an argument that if Trump's right, that, the statute gives him the power to impose tariffs for any length of time, for almost any reason, at almost any rate. Maybe there's a non-delegation problem. And so even though the statute, in my view, seems to allow regulated importation, then maybe there's a non-delegation problem. But in my view, it would be solved by that retail versus wholesale. You assess each tariff. Is it consistent with the statute? Is it not? So, but those are lurking in the background here.
Interesting. Well, for Trump's part, he has already doubled down on his ability to tariff. Trump wrote on Truth Social that in response to the Supreme Court's ruling, he would be raising the 10% worldwide tariff to 15%.
Well, he first imposed the 10%.
Oh, yeah, actually.
And then he said, actually, just kidding, 15%.
And then like 24 hours later, he was like, and I'm upping it.
So is this like a snub at the Chief Justice who was like, he just raised the tariffs totally unpredictably one day and then another day, and Trump's like, you thought I would be more predictable with this authority. Joke's on you. Yeah. Like 10%, no, 15%. No, like... Anyway, go on.
He tweeted possibly one of the best Truth Socials of all time. That starts out with, the Supreme Court, this is Donald Trump, the Supreme Court will be using lowercase letters for a while based on a complete lack of respect.
Oh my gosh.
He has put the Supreme Court in lowercase of the United States accidentally and unwittingly gave me as president of the United States far more powers and strength than I had prior to the ridiculous, dumb, and very internationally divisive ruling. For one thing, I can use licenses to do absolutely terrible things.
Terrible in
countries.
Quotes.
Yeah,
terrible. Where does the quote come from? Why does he quote?
No idea. Who is he quoting?
Well, I don't know.
Things, especially those countries that have been ripping us off for many decades. But incomprehensibly, according to the ruling, I can't charge them a license fee, but all licenses charge fees. What's he going on about this? He's saying that IEEPA would, in theory, give him the ability to license other countries.
Right.
He's like saying there's a roundabout way he could do this.
Yeah, there is a passage in there that allows, I think, him to use licenses in IEEPA. And Trump, I guess, is saying, but wait a minute, like we've routinely required fees to get a license as like a privilege.
Like the same thing, basically.
Okay, that's fascinating.
Okay, fast forward a little bit. Our incompetent Supreme Court.
Oh my gosh, he talks about birthright citizenship here.
Yes, you didn't know that?
I didn't.
We have to get to this part because he shouts you out. Okay.
Well, not me personally, but my issue.
Okay. Our incompetent Supreme Court did a great job for the wrong people, and for that they should be ashamed of themselves. But not the great three. The next thing you know, they will rule in favor of China and others who are making an absolute fortune on birthright citizenship by saying the 14th Amendment was not written to take care of the babies of slaves.
In quotes.
Which it was as proven by the exact timing of its construction, filing, and ratification, which perfectly coincided with the end of the Civil War, all caps. How much better can you do than that? This Supreme Court will find a way to come to the wrong conclusion.
This is fascinating. So he's basically saying, okay, you can rule against me once, I get it, but don't mess this up twice. Don't mess up the birthright thing too. That's a fascinating Truth Social.
Is this something like all of your historical knowledge? This has happened in the past. It must have, where the executive and the Supreme Court are just kind of beefing.
Yeah, remember Sam Alito, friend of the pod, and Barack Obama, friend of the pod. Sorry, can I?
Everyone's a friend of the pod.
I think there are a few enemies of the pod, but I haven't mentioned them yet. But the Citizens United decision and Obama browbeating the Supreme Court and Sam Alito going, not true, the State of the Union. And then Sam Alito has not showed up to any State of the Union since then.
Right,
so this has sort of happened. But so where did I hear this? I might have been having dinner with another law professor last night who mentioned that after the Trump immunity decision, apparently Trump went up during the State of the Union, went up and pointed at the court and said, I won't forget it. I won't forget it. I wonder what he'll say this time. I won't forget it. Yeah. I won't forget it, but I'll be angrier or something like that.
That's so interesting.
So actually the State of the Union is tonight, I think, the day we are recording, so people listening could tell us, could figure out what actually happened.
We'll know what happens. It is always interesting. They're not allowed to react, right, the justices, so they just kind of sit there while everyone else is freaking out around them, and they look relatively calm. Yeah,
potted plants. I don't know. The whole thing seems weird. Why do they go? Why do they go at all? But anyway.
So at the end of this all, one thing that hasn't been addressed is, do they have to give the money back? What happens now that this decision has come out? That they've collected this tax from American taxpayers. Do they have to give it back to us?
So it might depend on whether the tax was. So certainly some of the tariffs might have been paid by the manufacturers, but the costs not actually passed on to consumers. I don't know what the amount of that is. But the short answer, Kathryn, is that is a great question and nobody knows.
Okay. Well, yeah, I saw that Kavanaugh was like, this could be, he said it could be whack or something. He said it could be kind of crazy. Okay, I didn't put that part in here. But he said messy, I think is what he said. This could be messy.
Yeah, but you know what? That doesn't mean the law isn't what the law is, right? So Kavanaugh might be right, but he's not right because if he's wrong, it would be messy, right? To get the refund. So like, I don't know. Like, I'm not moved by such arguments.
Okay.
I don't know.
It just seems like, how would you even determine such a thing? How much people get back based on, it's like a math equation I can't even fathom.
I have no idea where the money is, no idea if you can get it back from consumers. But, maybe the ruling is the lower courts will figure this out and it'll just be prospectively no more tariffs. But, you're out of luck if they've already been imposed, which, by the way, is, again, another reason why historically judicial power, tariff by tariff basis. So you invalidate this particular tariff and then you can trace more easily, I think, probably where the money came from, if it was actually passed on to consumers and so on. But again, I'm not on the Supreme Court, so woe is me. Or woe is everyone else. No, okay, I'm just joking. So who knows what they're going to do?
All right. Well, the other thing that I thought was very interesting about this decision. Well, first of all, I have a little bit of beef with the Supreme Court because they release all of their things in like huge PDFs and they don't break them up or anything. They just leave it to the people to sift through. It's one PDF.
Well, if you look at the heading, it does tell you which
heading, but like it's just
it tells you which opinions.
If I know what I want to read, God, I could organize this so much better.
You flip halfway through and you look at the top and it's like, okay, Kagan concurring or Gorsuch concurring.
I want
and then
it
you figure it out that way.
Separately. Why is it all in one match? 170 pages? That's absurd.
The mathematically sensible way to do it is you go to the halfway point, you see who it is, and then you go to the half of the half until you figure out, whose opinion it is.
The margins? They've got like 4 inches on these boys. So they got like a little block of text. Like it doesn't have to be 170 pages. They could. What style is that?
Presumably it's because they want lawyers and law students to write in the margins and take notes. And studies. I have no idea.
Oh my gosh. Okay.
I have no idea.
Sorry, that was definitely a weave, but it got to me. The other thing I found interesting in here was how much Gorsuch in particular was kind of beefing with everyone. He had things to say about every single group of people. Of course, my personal favorite was everything he had to say about the liberals.
That would be your favorite.
It was, of course, my favorite. And it was a lot. He really went after them right away at the beginning. So I'll read a little bit right from what he says. Gorsuch wrote, "My concurring colleagues contend that IEEPA does not grant the president the power to impose tariffs. In doing so, they make thoughtful points about the statute's text and context, but their approach today is difficult to square with how they have interpreted other statutes. Dissenting in past major questions cases, they have argued that broad statutory language granting powers to executive officials should be read for all it is worth. Yet now, when it comes to IEEPA's similarly broad language granting powers to the president, they take a more constrained approach." Boom! That's so good. And then he gives a bunch of examples.
Yeah, this is cutting. This is very cutting. And isn't it true? Cutting. And isn't it true? I mean,
it's so true. So here's one of his examples. It was the National Federation of Independent Business versus OSHA. And basically,
this was the vaccine or test mandate, or the vaccine or test and mask mandate that OSHA imposed, right? So OSHA has authority to create occupational health and safety regulations for the workplace. And
that's the quote. OSHA is tasked with promoting safe and healthful working conditions.
And so they imposed a vaccine requirement on almost 100 million Americans.
Is that seriously safe and healthful working conditions?
Well, the Supreme Court said no, but the liberals said, oh, of course it is. Right? And so
that is crazy.
So time after time, what Gorsuch is saying is in these cases involving the Biden administration or the Obama administration, these liberal judges were very quick to find sweeping delegations of authority to the administration to enact the Clean Power Plan, to do the vaccine or test mandate,
student
loan forgiveness under statutes that were cryptic at best, that were ambiguous at best. And yet, so for example, the student loan case, I think Gorsuch had the language, but it's something like waiver modify.
Waiver modify any statutory or regulatory provision applying to a federal student loan program.
Okay, so waiver modify.
During a national emergency.
Waiver modify a regulatory provision applicable to the student loan program. So the Biden administration said, aha, well, we could waive the debt itself, which obviously that's not, well, actually, they were a bit more clever than that.
Okay.
They were, but it was too clever by half. They're like, well, there are some conditions that under which we allow discharge of student debt. So if we waive those conditions, then anybody could discharge student debt, which is just not at all how this is supposed to work, right? And so look, again, but the three liberals were like, sure, it allows Biden to do that, right? The Clean Power Plan was imposed under the provision of the Clean Air Act, where it allows the agency to impose the best systems of emissions reductions on power plants. And the question was, is a system of emission reduction just a technological process within the plant, like in the fence line? Like, how can you produce coal as cleanly as possible, right?
Yeah.
With as few emissions as possible. And they interpreted a system of emission reduction to allow them to remake the whole national energy mix, to just say, we're not going to do coal anymore. We're going to shut down coal and we're going to move to clean energy because that is a best system of emission reduction. Where actually system was originally supposed to mean just the process in a particular plant. And the three dissenters here were like, sure, do the Clean Power Plan, right? And then the helpful, and so like Gorsuch has them like dead to rights about this. So it's like, regulate the importation of is much clearer, right, than any of those provisions were. And yet you were quick to find these sweeping delegations under those ambiguous and cryptic statutes, but not a delegation here.
They literally just give, the liberal justices just give Democratic presidents more power and Republican presidents less power. It's like so clear as day that it's crazy that anyone can still think that there is this, I mean, not to be a doomer, but it's crazy that you can think that the court is this neutral arbiter of the law when in fact, it's only some of the court that is even pretending to be a neutral arbiter of the law.
Now, some people could accuse the three Republican-appointed dissenters of being inconsistent, right, for striking down, but they have an explanation, right? I mean, the liberals don't really have an explanation. They do not refute or rebut in any way Gorsuch's accusation of hypocrisy. The three conservative dissenters, like, why do they vote to strike down the Biden stuff, but would uphold the Trump tariffs here? They had an explanation, which was that the major questions doctrine does not apply in full force in the foreign affairs context, because in foreign affairs context, Congress prefers to delegate broad power to the president, that this is routine, that the premises of the major questions doctrine doesn't hold as a matter of congressional intent.
See, that makes sense. I feel like you said that this doesn't make a lot of sense to you as an idea. This is Thomas's argument,
okay,
right?
Kind of. So Thomas says something else about like the non-delegation doctrine doesn't apply at all in foreign affairs. And I think that's crazy. I don't think that's right. I don't think there's much evidence for that. But
you can't delegate out. You can't. Can you explain it? You can't delegate your power to a foreign entity? So that's true. But you can't delegate. So the theory, Thomas's theory is, you can't delegate to the president power that affects the private rights and conduct of Americans. But you can delegate to the president power that historically was royal prerogative power. Okay? And so historically, the king had power over foreign commerce. The king had power over actually war and peace. So that's a little awkward for Thomas. And what Thomas basically says is, if these were historically royal powers, then Congress can redelegate all of this power back to the president. And I think that's crazy, because why is Article 1, why did they enumerate power in Article 1, Section 8? There's a whole chapter about this in my forthcoming book. Good. I don't know. So you answer.
So part of it was to limit the scope of the national government's power. There's some debate about that. But really, when you look at it, most of the powers in Article 1, Section 8 were historically royal powers. And if you don't want the president to exercise these historically royal powers, then you should, enumerate them and give them to Congress. And the fact that the framers gave these powers to Congress over war and peace, right? It gave the Senate a check on the treaty power.
Sure.
It gave Congress the power over commerce, weights and measures, regulating the army, right? These are things historically the king could do. It just seems weird to say that Congress can give back those powers that the framers really wanted to give to Congress. And so the non-delegation thing just doesn't make too much sense. Like, maybe it's more relaxed in the foreign affairs context, but Thomas said it just doesn't exist, and that's super weird.
I think just from a sensible standpoint, it makes sense that the president would have more authority over foreign affairs because he's the one doing a lot of those negotiations. I mean, who's going to go in and negotiate with other countries? It's the president. And if the person he's negotiating with, say it's the head of China or whoever, knows that he doesn't have a lot of power when it comes to foreign affairs, that would really hamper his, negotiating power, right?
That is a very based view of you, Kathryn.
Well, the president needs some leverage when he's going to go in and represent, right? So, but if they know he can't do anything, he has no leverage.
The problem is that the president can only act consistently with the distribution of powers in the Constitution. So, for example, Congress has the power to regulate foreign commerce, and the Senate could ratify a treaty that the president negotiates with, like a trade agreement. Okay, what the president can't go in and do is say, here's the deal that we want, and I alone can impose this. The president can negotiate it and then could ask Congress to enact it under its foreign commerce power, or the Senate to ratify it as a treaty. But the president can't just do that on his own. He can negotiate on his own. Now, it's true that Congress often delegates like broad authority to the president, like over sanctions. So how did the Iran nuclear deal come about? Well, because Obama had delegated authority to sanction or not to sanction Iran, and he used that to negotiate an agreement with Iran on the nuclear program.
Yeah, that sucked.
It was a terrible deal. They didn't follow it, and that's like a sort of a separate problem. But the only reason Obama could do that is because Congress had delegated the sanctions stuff. But then the next president could renege on that, right? Because it's not a treaty, it's not a law, it's a law that delegates to the president power to vary it. So the president can only act consistent with the distribution of powers. And here, tariffs is a power, foreign commerce is a power given to Congress. And so I don't think there's any non-delegation exception for foreign affairs. It could be that it's more relaxed, that just by its nature, there's only so much Congress could do precisely because of the reasons you articulated. Because things are fast moving, the president has to have flexibility to negotiate because you don't know what foreign governments are going to do, which is why, Kathryn, for exactly the reasons you pointed out, Congress historically has delegated broadly to the president. But that's not the same thing as saying what Thomas is saying, which is there is no non-delegation doctrine in foreign affairs. And I think Gorsuch kind of torches that argument in a way. Like I don't want to be overly dismissive of the Thomas view, but that's I'm skeptical of that view. I will say back to the Kavanaugh thing. Yeah. They say, look, non-delegation is more relaxed and there's no foreign policy problem here, or there's no non-delegation problem here. And with respect to major questions, which is that a non-delegation, does that enforce the non-delegation doctrine? Does it not enforce the non-delegation doctrine? There's some debate, between Barrett and Gorsuch about this. But the point here is, again, the three liberals have no explanation for their inconsistency. Yeah. At least the three dissenters say, look, major questions, non-delegation is more relaxed in the foreign affairs space. Here's our reasons for it. Here are our evidence for it. So totally plausible. There is one law professor who shall not be named. Maybe he is an enemy of the pod. He knows who he is if he's listening to this, which he's probably not. But there's at least one law professor who said that the three dissenters are inconsistent hypocrites, but the three liberals, they're perfectly consistent. Highly implausible take. Highly implausible take.
Terrible take.
Whether true or not, what I can say is the liberals do not defend themselves against the charge. Kavanaugh at least has an explanation for their supposed inconsistency.
How do they go back and forth defending themselves? How do they put these things together from a logistical standpoint? They all write their own. How do they know what to argue against? How do they know that Gorsuch is going to call them out ahead of time and here are my points? Yeah. This could go on forever.
They circulate, it could go on forever, which is tricky. But at some point we have to say no more changes, right? But they circulate drafts in advance, which is probably why Barrett wrote her concurrence, because Gorsuch kind of gratuitously, but I can see why he's doing it, attacks her understanding of the major questions doctrine. Okay. And I kind of like the Barrett view because I've written an article kind of articulating the same view. But so they have a dispute over the major questions doctrine. Is it the substantive canon that enforces non-delegation, or is it this just linguistic canon, like how reasonable Congresses are expected to delegate power? And Gorsuch calls her out, what's reasonable? What's Congress likely to have done? Yeah. Well, it depends on substantive beliefs about the background legal features. I don't think Barrett disagrees with that. I think the difference is very narrow. I think Gorsuch is going to be more quick to say, I don't care what the best reading of the statute is. I want a very clear statement before Congress does something big and important. And I think Barrett asks herself, what is the best reading of the statute? Understanding that Congress has certain substantive normative background principles in mind when it does things, I think is a very narrow disagreement. But to go back to your point, Barrett probably only wrote this because Gorsuch started attacking her about what exactly the major questions doctrine was. So,
right. So it doesn't come out and she was like, OMG, like he's going after me. Like they all see these things ahead of time and they get to respond.
Correct. I mean, she probably saw the draft and was like, OMG, he's attacking me. I'd better write a concurrence, and it gets pretty spicy, but like, what are they fighting?
Spicy.
What are they fighting over? It's this very narrow thing, I think, that they're really fighting over.
Interesting.
So we'll
okay.
see. So does that, listeners, does that explain the major question, the tariff decision satisfactorily?
I think so, except for that we're being a little wishy-washy. Like, what side are we on? Do you think we should?
What side are you on?
I think I'm with the dissent, but I also see all of the arguments.
Wait, that's
I think I'm
based
with the dissent.
To see all the arguments?
Yes, I do. I see all the arguments. No, I think that's rational.
Okay,
that's
all right,
rational.
That's the rational
but
part.
I'm still with the dissent based, obviously. I mean, I just think
I think the dissent is so okay. What is the bottom line? I think the dissent is right on the statute on whether regulate importation include tariffs, and then having said that, I'm anxious to give the president that kind of power when Congress arguably would not have done so without the legislative veto that has since been invalidated. That's what gives me heartburn. And then, there's the major questions. But again, I have the Barrett view, like what's the best reading of the statute? And here, like I think regulate importation probably includes tariffs, even if I were to deploy major questions. I think the best reading probably includes tariffs, but there's some non-delegation concerns. But again, those can be addressed on a tariff by tariff basis. So maybe the answer is yes, it includes tariffs, but it should be done on a case by case basis. But if we're going to stack the deck against the president, I would do it because of the legislative veto problem that Congress never enacted this statute, right? It enacted a different statute that no longer exists because the court invalidated the legislative veto. So that would be making things up a bit. So does that make me like radical a little bit? But it'd be a sensible making up of things because again, we're already making up things.
Right, everything's made up.
Well, because Congress didn't enact this particular statute. Right. So that's my thought.
And that's such good. I didn't hear that anywhere else, the legislative veto thing. I didn't even know the legislative veto ever existed. So I have learned something new today. Thank you. I appreciate it.
It is my pleasure. Always happy talking about the legislative veto.
Should we talk about this piece that brought me so much joy in the last couple minutes we have here? Because Jeffrey Toobin, yes, that Jeffrey Toobin wrote an op-ed in the New York Times. How is anyone still publishing his stuff? Why? How do you come back from a Jeffrey Toobin-like incident and continue to write op-eds in the New York Times? I don't know.
I'll take a pass and answer that question. I'll leave it to others.
He's back. Apparently, he didn't do enough to get canceled, which is crazy. The plan for a radically different Supreme Court is here, is what he writes. It's a glowing puff piece about an organization that I'd never heard of called the American Constitution Society, or ACS, and how they're trying to get more liberal justices confirmed. It's supposed to be a liberal Federalist Society, basically, kind of their counterpoint. So maybe we should start out with, okay, what is the Federalist Society for those who don't know, and what are they trying to do exactly here with the Constitution Society?
Okay, so the Federalist Society was this organization, I think started by students at Yale, but maybe it was like a couple of the top law schools in like 1980. That was basically a reaction to the Warren Court. It was a reaction to progressives' dominance in academia. And they advanced a theory of constitutional interpretation called originalism, right? This idea that we should interpret the meaning of the Constitution with its original public meaning. The Federalist Society didn't originate originalism, but they, were just a collection of students that generally favored the Supreme Court not making stuff up.
Sure. Yeah, that's good.
So like the context, and I love this, and I think we have the clip, right? So what I love to tell my students about the movie Dirty Harry. with Clint Eastwood. You know, Clint Eastwood is a detective in San Francisco.
No, I don't know. I don't watch movies, but I do know Clint Eastwood is based.
Okay, you have to see this movie. And in 1974, or 1971, the Clint Eastwood came out, and it was like an indictment of the Warren Court. The Warren Court was making up all of these procedural protections and criminal protections for criminal defendants, like Miranda warnings, suppression of evidence, and people thought this was all super crazy. And actually, there's a law professor here in Minnesota, Michael Stokes Paulson, who wrote a law review article called "Dirty Harry and the Constitution."
No way!
Yeah, great article. I think.
Oh my gosh! Shout out! My husband had him as a professor.
Mike Paulson.
Yeah.
Oh, very good. And I think he also wrote an article called "The Starship Enterprise in the Constitution" or something. So like really, really, really clever.
That's fun.
Basically saying like all these liberal Warren Court stuff is super crazy, and arguably originalism was partly a reaction to it. And Clint Eastwood has this line being like, "If this is the law, then that's crazy." And that's how FedSoc and the people in that milieu, that environment, sort of understood it. So let's run the listeners. It's about 2 minutes. Hilarious. You got to watch the full movie though. But let's run this clip from Dirty Harry.
You're lucky I'm not indicting you for assault with intent to commit murder. What? Where the hell does it say you've got a right to kick down doors, torture suspects, deny medical attention and legal counsel? Where have you been? Does Escobedo ring a bell? Miranda?
Those are Supreme Court cases.
I mean, you must have heard of the Fourth Amendment. What I'm saying is that man had rights.
Well, I'm all broken up about that man's rights.
You should be. I've got news for you, Callahan. As soon as he's well enough to leave the hospital, he walks.
What are you talking about?
He's free.
You're letting him go?
We have to. We can't try him.
And why is that?
Because I'm not wasting $500,000 of the taxpayers' money on a trial we can't possibly win. The problem is we don't have any evidence.
Evidence? What the hell do you call that?
I call it nothing.
That's a gun.
Zero.
For the listeners.
Are you trying to tell me that ballistics can't match the bullet up to this rifle?
It does not matter what ballistics can do. This rifle might make a nice souvenir, but it's inadmissible as evidence.
And who says that?
It's the law.
Well, then the law is
Stupid.
crazy.
This is Judge Bannerman of the Appellate Court. He also holds classes in constitutional law at Berkeley. I've asked him for an opinion. Your Honor?
Well, in my opinion, the search of the suspect's quarters was illegal. Evidence obtained thereby.
This is what we call an
such as
advisory
that hunting
opinion.
rifle, for instance, is inadmissible in court. You should have gotten a search warrant. I'm sorry, but it's that simple.
Search warrant.
All
There
right.
was a girl dying.
She was, in
wait.
fact,
I'm
dead,
sorry.
according
Let
to the
actually
medical
keep rolling.
report.
This
But
is
I
a great
didn't know
part.
that.
The court would have to recognize the police officer's legitimate concern for the girl's life, but there is no way they can possibly condone police torture. All evidence concerning the girl.
Okay, let's stop there. So, okay, you thought the girl was dying. Well, she was actually already dead, so you could have gotten a warrant. Okay, the point of showing this clip is this was the Warren Court, and people, on the conservative side of the aisle was like, you're just making stuff up, Like, where does it say in the Fourth Amendment that just because a search is conducted incorrectly under the Fourth Amendment, that means a criminal for whom we have like dynamite evidence gets to walk free? I mean, like historically, maybe you could do a tort claim. So while he's sitting in jail after being convicted, he could sue them for trespass. Like, I don't know, but like you still go to jail because you still killed the girl.
Yeah.
And, so when Clint Eastwood says, well, then the law's crazy, that's kind of how these people felt.
Yeah.
And so they
Agreed.
started. And it was a great time. What a time to be alive that was.
It still happens though. You'll hear about that kind of thing where something they didn't. Oh, you know where it just happened with that Luigi Mangione case? They have this debate. The defense argued that basically they shouldn't have gone through his backpack because they didn't have the right to go through it yet.
Yeah, if they win that issue, then the law currently still says what the Warren Court says, by the way. So like, although originalism is ascendant on the Supreme Court, the exclusionary rule, the suppression of evidence, is still the rule. And so I guess he would walk.
That's
because
nuts.
you'd suppress it, right? And so that's what Clint Eastwood said.
Yeah.
And it's probably totally ahistorical, totally unoriginalist. The exclusionary rule has no basis in the Constitution. And so anyway, so the Federal Society and academics and judges started developing this idea called originalism to counteract the Warden Court. Now, originalism, to be clear, isn't like this invention of the 1980s. It was how they always did law until the progressive era, right? It's like if you look at James Madison and Marshall, like they all said, like, how were the words understood at the time that they were enacted? Like that's just how you did law. That's just how you did law back then. So the fascinating thing about this ACS piece. So the American Constitution Society, I guess, does the piece say it was like in the 2000s?
I don't know. I don't even think it says. It really can't define itself. He's having a hard time coming up with the words to define what this like rebuttal would be to the Federalist Society.
Exactly. So they say, ACS has this radical plan to remake the Supreme Court. How? Like, what theory do they have to replace originalism? And so he's interviewing, Jeff Toobin, I guess, is interviewing the president of ACS, the American Constitution Society. Fun aside, Phil Brest, the president of the ACS, was a classmate of mine in law school.
Wow.
And actually, I think is the nephew of Paul Brest, who coined the term originalism. It was a pejorative. It was like, originalism, like, this archaic, who cares what the founders thought? But it stuck. We're like, actually, this is a great word.
Okay, so what does he say that they will replace the Federalist Society with?
Well, so are they going to replace the Supreme Court with, or the justices? Like, what theory will replace originalism? So here's Toobin. As for what those judges will stand for, as opposed to what they stand against, Mr. Brest, the ACS president, has no clear answer. And I'm thinking, so you wrote a whole article about the radical plan to remake the Supreme Court, and that radical plan is?
Nothing?
We don't have a plan. We don't have a plan. Or is the plan just raw political power? Like, you got to have some theory, right? But if you don't have a theory, then what's your plan? What's motivating you? Raw political power? I mean, this seems kind of crazy, but maybe we will have time to unpack originalism versus the alternatives. We've been promising a deep dive, so maybe we'll have to do that in some future episode.
Yeah, we'll have to keep doing it because I think that it's interesting to think about the liberal response, which is just, in my opinion, I think liberal activism. And how does the right respond with that? Is our view of originalism enough? Is there something that, are we ever going to win if we stick to originalism? Is there actually an argument to be had for conservative activism? I don't know, maybe.
That is a very based question and one we don't have time today to address.
Teaser. We'll talk about it in the future. Well, thank you so much for joining us. Grace, shout out. We missed you, but I think it was still a pretty good pod, and we enjoyed having you all along for the ride. So we'll see you next week.
Grace, let us know how we did.
And
also, our listeners, rate us, like, subscribe, tell your friends. Very, very important. And thank you for tuning in, and we'll see you next week.